Let's have a look at the main topics that we're going to deal with in this course. So firstly, go right down to basics, strip it all down. Let's get the most fundamental principles in place. And then we're going to go through, and that will be the nature and purpose of expert evidence. Then we're going to build from there. So the next point that we'll cover is the relationship between the courts and expert witnesses. Now, again, that is your very next step that you take. Firstly, understand what is expert evidence. That helps to orientate you, whether you're an expert, whether you're a legal practitioner. Once you've got a clear understanding of what an expert is and what an expert can and can't do, you've already dealing with your experts with a lot more confidence. If you are an expert, you understand your role with a lot more confidence. So that's the first step. The very next step is what I regard as being at the heart of the nature of expert evidence, which is, it goes to the purpose of calling an expert, the reason for calling the expert. And that runs to the relationship between the courts and expert witnesses. As legal representatives and as experts, we're so caught up in the preparation of the trial, getting the trial ready, but ultimately, it's the presentation in court which matters. And once you get into court, it's the relationship between the judge and the expert, guided by counsel, that ultimately matters. And everything you do leads up to that moment. Because from the judge's perspective, he or she has not dealt with this case, has not dealt with this expert, has not dealt with the issues. And so all the preparation means nothing until you're actually in court, and from the judge's perspective, this is now fresh. And that's ultimately all that matters, is the opinion of that judge. Obviously, many cases settle, but the more you prepare for presenting evidence with that philosophy and with that approach, the more you're going to settle on the front foot. Then the next point we'll look at is establishing the right to give expert evidence. So that now runs from the nature and purpose of expert evidence. You'll see it also builds actually on the relationship between the judge and the expert, because that right to give expert evidence runs to what it is that you're trying to achieve, and that is to build credibility with the judge. Then the next point is to develop a logical argument. Then flowing from that is the factual basis for the expert opinion. The management of facts is the next building block, the next level up. Very important that facts are properly managed, because they, again, are at a little higher level now. They're the next level of that Jenga block, if you like, that's got to be solidly in place. Otherwise, the whole tower is going to topple over. Then reliability, relevance, and admissibility of expert evidence. Once we've had a look at the real fundamentals, developing a logical argument, dealing with the factual basis for the expert opinion, then we're going to look at some issues that play their way all the way through all of those aspects, and that's reliability, relevance, and admissibility of expert evidence. A lot of those are a bit more technical, relevance and admissibility, but reliability is something that goes to that relationship between the court and the expert in a sort of, let's say, a sort of softer skill type of way. In other words, how do you get the court to trust what the expert is saying? As an expert, how does the expert get the court to trust the expert? And a lot of that comes down to having these factors in place. That will allow you to be trusted. Then you've got to take it a step further, and you've actually got to demonstrate trustworthiness. And then we have a look at one or two slightly more technical issues. 1.7, experts should restrict themselves to matter within their expertise. Again, that's tying together all of the previous topics, but it sets out the limits of expert evidence, and a mistake that experts often make, which is to go outside the four corners of their field of expertise. It can be a real problem. And then finally, the prospects of an event occurring should be expressed in probabilities in civil cases. That's something which we often hear about. I get quite a lot of questions about this, and I think that there's a bit of an uncertainty about the relationship between the probabilities in civil cases and how scientific certainty plays into that. And we will have a look at that in detail in that particular topic. That then gives you the general principles. And in chapter 1, in the next video, we'll look at the outcomes which you should achieve once you've been through those 7 topics.